Thank you, Chairperson, for giving me the floor, and good afternoon, ladies and gentlemen. The underlining theme of this session, if you like, is that private parties are the primary intended beneficiaries of the regional integration process, and that an effective rules-based system is vital in ensuring that the benefits of regional integration actually accrue to these private parties. The private parties defined as private traders and also individuals. We've talked a bit about SADC since morning, but now we shift our attention to COMESA. And I extend the discussion further by looking at how the rights of private parties are protected within the framework of community law in COMESA. The focus of my discussion will be on the recent landmark case that was decided in the COMESA Court of Justice in a case between Polytol Paints and Adhesives Manufacturing Company and the government of Mauritius. I start by defining community law as a unique form of international law, one that not only consists of contractual obligations between member states, but goes further to create institutions with powers to take measures and adopt legal rules. And then these measures and rules create rights and obligations for member states and their authorities, but most importantly, also for individuals within the jurisdictions of the member states that are party to these agreements. The conferring of rights to private parties and the ability for private parties to enforce these rights in regional institutions such as the regional court is a hallmark of community law. It shows how member states limit their sovereignty to enable private parties to actually enjoy these rights and to enforce them where they've been violated. The origins of community law as a concept are in European Union law, where it has been the bedrock of regional integration as it has ensued over the years. It has anchored the rule of law within the EU and has brought about a certain and predictable legal order. Importantly, natural and legal persons are able to invoke it for the protection of their rights conferred on them by EU legal instruments. Closer to home, we know that regional integration in Africa proceeds within the framework of regional economic communities. And the designation as such initially suggests that these are systems of community law. However, the extent to which they're actually effective and enforceable legal regimes still remains uncertain, and particularly when it comes to the protection of the rights of private parties. The judgment of the COMESA court in the Polytol Paints versus Mauritius case is instructive on the extent to which the COMESA legal framework is indeed a form of community law. So the case involves Polytol Paints, a company incorporated in Mauritius, as the applicant and the government of Mauritius as the respondent. There are two provisions in the COMESA Treaty which are central to the case, namely Article 46 and Article 26. These are provided in full text in the summary provided in your folders. And I'll actually emphasize on these two provisions as I go along. The background to the case is such that Polytol Paints was an importer of Kapki paint products from Egypt. And as part of requirements to join the COMESA free trade area, Mauritius removed duties on products, including those at issue in November 2000. This was in adhering to Article 46 of the treaty, which provides that member states shall reduce and ultimately eliminate all customs duties by the year 2000, that's in subparagraph 1, and shall not impose any new duties on products, that's in subparagraph 3. After becoming a member of the FTA, Mauritius introduced a 40% customs duty on certain products from Egypt, including the products at issue, Kapki paint products. The company tried in vain to remonstrate with officials of the Mauritius government. This was to no avail. It also then pursued the case within the domestic legal system in Mauritius. In throwing out the case, the Supreme Court of Appeal in Mauritius stated that in the absence of legislation incorporating the treaty into Mauritius's national law, the non-fulfillment of obligations under the COMESA treaty could not be enforced by the national courts of Mauritius. And so as a last resort, the company brought the case before the COMESA Court of Justice and argued that the duty that was imposed by Mauritius was an infringement of Article 46 of the COMESA treaty. And it actually claimed a reimbursement on the amount of duties that it felt it had been made to pay unlawfully. In considering the case, the COMESA Court of Justice divided the claims into two. First were those relating to the alleged failure by Mauritius to give the COMESA Treaty legal effect within its territory, and second were those based on the imposition of customs duties on the said products. With regard to the first set of claims, the court ruled that a private party can only bring for consideration of the court matters relating to acts or measures that actually infringe provisions of the treaty. This is provided for in Article 26 of the COMESA Treaty. It ruled that private parties are not allowed to challenge in the court matters relating to the non-fulfillment of obligations by a member state, such as the general undertaking that's in the COMESA Treaty in Article 5 of actually giving legal effect to the COMESA Treaty within the national territories. This is only within the purview of other member states or the COMESA Secretary General, as provided for in Article 24 and 25 of the COMESA Treaty. The court therefore felt that it did not have to make a determination on whether Mauritius had actually failed to give effect to the COMESA Treaty within its national law. In spite of that finding, however, the court ruled, as it considered the second set of claims, that by reintroducing duties on the said products, Mauritius had infringed Article 46 of the treaty. Importantly, the court held that the obligation to eliminate customs duties and the prohibition from introducing new duties contained in Article 46 actually creates an enforceable right for private individuals, which, if infringed, can actually be enforced by them in the court on the basis of Article 26. So essentially, it's reading Article 46 in the light of Article 26 that gives this enforceable right and actually allows private parties to challenge certain infringements in the COMESA court. So in this instance, the applicant had the right to import the products duty-free, and it would not have been liable for the duties if Mauritius's regulations had been in line with the treaty. The breach of Article 46 by Mauritius therefore resulted in this right being violated, and so the court ruled that the government of Mauritius should reimburse the applicant duties that it had been wrongfully made to pay. So the ruling by the COMESA court indicates that COMESA is based on a system of community law, that the COMESA legal framework does not only consist of contractual relations between contractual obligations between member states, but it actually goes further to create rights for private parties, which these private parties can actually enforce in regional courts where their rights have been violated. This is clearly seen in the case of the articles that I've highlighted, Article 46 and 26. And it's especially important to note that the company's case was helped mostly because of the clear and unconditional way in which Article 46 is actually framed. Because the provision is actually clear and unconditional, and because the right to import duty-free that it bestowed on Polytol paints could actually be enforced by the company in the regional court, it shows that the court showed that the provision in question actually has direct effect in the territories of COMESA member states. Now, direct effect is a central concept in the field of community law. It only means that a right is available to private parties in all jurisdictions, and in this case, particularly those that were participating in the COMESA free trade area, and can be enforced in the COMESA court by these private parties, irrespective of whether the COMESA treaty has been domesticated into the national law of respective member states. The effectiveness is especially seen when we consider that the legal regimes of different COMESA member states differ quite significantly. On one hand, there's some member states that follow the monist approach, where a treaty automatically becomes part of national law at the time that it's being ratified. And on the other hand, there's the other countries that follow the dualist approach, where a separate legislation is actually needed to incorporate a treaty into the national law. The court, however, highlighted that the objectives of the COMESA treaty can only be achieved where all members fulfill their obligations, and so member states cannot use their lack of domestication of the treaty as an excuse to say that the rights of private parties are not available in their jurisdiction. On the contrary, in this case, the right to import the products duty-free was available to Polytol paints, even if Mauritius had not domesticated the treaty into its national law. And the ruling by the COMESA court actually shows, and the direct effect nature of the provision overcomes a difficult scenario where the rights contained in Article 46 to import duty-free are actually available in some jurisdictions or in some member states, and not in other member states, just because some member states have not domesticated or incorporated the COMESA treaty into their national law. And it actually serves as a good lesson on how such provisions should be drafted to ensure the promotion and protection of the rights of private parties. The government of Mauritius has since appealed and will continue to monitor the case, and a few other issues on the extent to which COMESA is indeed an effective form of community law will become clearer at the appeal stage of the case. But presently, the present ruling provides some important lessons for current and future regional integration processes in Africa, and I'll just highlight three. Firstly, it emphasizes the need for recognition and development of community law, characterized by legal instruments that create rights for private parties through clearly drafted provisions. The court's interpretation of Article 46 and 26 shows how vital this is. And because companies and individuals are the intended beneficiaries of the regional integration process, it's imperative that they must be able to invoke such provisions for the protection of their rights in regional courts, whether or not their national governments have taken steps to give the treaty domestic effect. This will ensure that the rights of parties are actually promoted and safeguarded in a clear and predictable way. Secondly, the ruling highlights the crucial role that the private sector has to play in inducing member states to uphold their treaty obligations. It's been well noted that African governments are averse to litigating against each other. And so where there are instances where the rights of private parties have been infringed, but yet there was a clear and unconditional provision, and in cases where national courts do not actually come in and offer redress for such breaches of the treaties, much may actually depend on the private parties actively enforcing their rights in regional courts to ensure that member states adhere to their obligations. Finally, and quite importantly, the ruling highlights how much effort must still be made to address the problem of multiple membership. Mauritius is both a member of the COMESA FTA and the SADC FTA. We've noted and we've talked, even Professor Erasmus has just highlighted how the SADC tribunal has been suspended and is expected to resume with more limited powers. Now, assuming that the measure that Mauritius had implemented was affecting Polytol paints imports from both a COMESA country and, as was the case with Egypt, and another SADC country, what would have happened was that Polytol paints would have had access to redress within COMESA, but not within SADC. And so the disparity that this brings actually negatively affects the predictability with which traders carry out their trade. It reemphasizes the need for streamlining and synchronizing the different dispute settlement mechanisms across the RECs. And I'll just particularly point out the COMESA EAC SADC TFTA arrangement, which was envisaged to actually resolve the challenge of multiple membership. Recent developments show that we may not be entirely on track to effectively sorting out multiple membership. But the point is that as trade liberalization efforts continue, much thought will also have to be put to how the different dispute settlement regimes can actually be synchronized to ensure that the protection of the rights of private parties, such as the reduced tariffs in the process of liberalization, are actually promoted and safeguarded in an effective and a predictable way. Thank you for your attention.